Okay.
Okay, thanks, Dave. Good morning, everybody. Welcome to the first session of Phillips Lytle's Real Estate Institute webinar series. We're excited to kick this one off today. You have my partner, Lindsey Haubenreich, and I for this first session on land use law and modern development challenges. Before we really get into it, I just want to start by saying a very happy birthday to my partner, Lindsey. She loves land use and zoning so much that she was happy to participate in this webinar on her birthday morning. So happy birthday, Lindsey.
Thank you.
Before we kind of get into the topics, I just want to preview a little bit. I think you may have all received some materials already and will after this, but just kind of take a look. We're obviously kicking things off today with land use and zoning, some modern development challenges, but we've got some excellent programming scheduled throughout the year from members of our real estate teams, our energy teams, our data center teams, environmental folks, as well as some special guests. A lot of topics that touch on, I've taken a look at our attendee list today. We've got a great mix, and I think a lot of these topics will be relevant to you all throughout the year. Trends in real estate development and financing, data center development is obviously everywhere, all over the news these days. Utilizing brownfields in a capital stack, permitting pathways, you'll hear me plug that one several times throughout our presentation today. Medical office and retail real estate, and then regulatory and energy related real estate issues, which if you're paying attention to the news is kind of constantly evolving in the state right now as well. So just to plug after today to make sure you're tuning into some of these upcoming webinars as well. They should have some helpful information. So today we're here on land use law and modern development challenges. Lindsey and I co-lead the firm's land use team. We have a deep bench at Phillips Lytle of attorneys across the state who work on these issues every day, whether it be multifamily, mixed use development, commercial, industrial, warehousing, telecom, renewable energy. We do kind of the broad spectrum all across the state, day in, day out. We're going to try and touch on these points today of zoning fundamentals, how you deal with community opposition, land use trends, and some case law updates. But, we're only going to be able to touch on this at a very high level. We have an hour, but Lindsey and I, live and breathe this stuff every day. And any of these slides, we could probably spend an hour on themselves. So to the extent that anybody has any questions in the presentation, Lindsey, you want to explain just the submission of questions real quick?
Yeah, we've got a little Slido extension in this webinar. So if you have any questions, if you're not registered, there should be a button to click to register. We'll accept you in. Just throw your questions or comments in there, and I'll be monitoring them, and we'll do our best to answer any and all questions throughout the presentation.
Yeah. So feel free to participate. Makes it a little more interesting. Just kind of kicking things off at a very high level, we thought it's kind of important to start with the basis of zoning. I know, like I said, I saw a lot of the attendees. I'm sure everyone here is, familiar with the zoning process, but I think when you are starting to think of how you're going to plan your approach to a zoning application, it's important to understand kind of what context you're in, what you can use to argue your position and move your application forward. And this kind of begins by understanding that zoning is a police power which belongs to the state. And the state has delegated land use control to municipalities through certain enabling acts: general city law, town law, village law, municipal home rule law. So all of the approvals and the processes that we're going to get into discussing, they are derived from these enabling acts. So anytime, you may have questions on procedure, scope, timing, process, we always say it's always good to go back to the enabling acts, kind of take a look at what they say. Local land use laws should not be inconsistent with those enabling acts. So it's always a good place to begin, even though you, of course, always need to look at your local zoning codes. So we always recommend starting there. I think our team often jokes with those who don't practice land use law that land use can be a little bit of the Wild West, depending on board dynamics, political dynamics, a small group of opposed citizens who may be vocal. But there are some rules. There are some ground rules. and some, processes that you can point to help move your application process along and reference the appropriate standards. Always helpful to have a lawyer involved, but we always say that that's kind of a good place to begin. I think, these are the typical types of applications, approvals that we're dealing with, that a municipality is dealing with, or you as an applicant are applying for. And they're created and laid out in the enabling acts and then expanded upon in each jurisdiction's local zoning code. I think it's important to take some time to understand and go through the nuances and differences between these approvals. It can help both, a landowner, developer, and the municipality understand kind of the extent of the process for each application, what boards are involved, and what the standard for approval is. It also can help you evaluate when you're just looking at the development of the site, what might be maybe a viable option, what the path forward looks like. So we kind of start just with those approvals. Before we even get into these approvals, at the very beginning, kind of the best case scenario is that what you want to do at a site is a permitted use in the code. So you figure out what zoning district you're in and you take a look at the code. And for example, you want to propose a warehouse and your zoning district lists warehousing as a permitted use as of right. That's kind of your best case scenario to be in. It means you are entitled to a building permit for that project, provided you can meet building code requirements. It's deemed appropriate for the area. So that's kind of the base level starting ground. But even when you are permitted use as of right, often a municipality will require site plan approval. So that's kind of a basic review that we'll begin with. And under those enabling acts I mentioned, local governments obviously have the authority to create planning boards who oversee the site plan review process. They can review, deny, approve, or modify proposed site plans, but those decisions must be in accordance with the requirements that are laid out in each jurisdiction's local laws. Typically, in the context of a site plan approval, the planning board's looking at the arrangement, the layout, and the design of a site plan. They need to be considering elements that are specifically laid out in the enabling acts and in the local code. So you'll go to your local code. Typically, there'll be a section on site plan review that'll lay out, 8 to 20 items that need to be shown in your site plan submission in order to get through that planning board process. And typically, the scope of that review is kind of site layout design, parking, access, ingress, egress, screening and landscaping, what your signage looks like, architectural features of the buildings, locations and dimensions of buildings, and setbacks of buildings, and then how that impacts adjacent land uses, and certain physical features that may be meant to protect adjacent land uses. So it can require a public hearing, but it's not mandatory. But really, the extent of site plan approval is connected with the layout of your site plan and kind of how your site functions and flows. So it's a pretty specific part of the review. Next, you get into special use permits. Sometimes we hear them called special exceptions, conditional use permits, restricted use permits. And there tends to be, I think, sometimes a misunderstanding when something is considered a special use permit, often from the public. I think a lot of times when we have special use permit applications, the public views that as kind of an elevated threshold that means a use is not appropriate and has to go through a very strict and thorough review. And it's only true to some extent. When a municipality in its legislative process makes something a specially permitted use, it is conferring authority to use property in a manner that's authorized by the jurisdiction. So it's not a variance. It actually includes a presumption that the use is appropriate and is in harmony with the neighboring uses around it. However, you have to show compliance with certain legislatively established conditions. So when you're going for a special use permit, you look at the code and there will typically be a number of factors that you have to show in order to demonstrate that you are consistent and in harmony with neighboring uses. But you are entitled to that special use permit if you can demonstrate those things. And I think that's an important part to always bring back into the discussion when you're presenting for a special use permit is If it's a solar project, this is deemed appropriate for this area, provided we've met these conditions, and you want to consistently be laying out in a public hearing, in the record, how you meet all those conditions. You need to make it as easy as possible for the boards to understand how you're meeting those conditions. And, it can be different in each jurisdiction which board is issuing special use permits. It doesn't necessarily have to be the planning board, it could be your town board, your city council, ZBA in some instances. So always make sure you're kind of taking a look, big picture, to understand what boards you need to go to. And if the next level of approval is a use variance, and this is one that we sometimes lovingly refer to as where zoning applications go to die. And maybe that's a little harsh. If a municipality is on board, perhaps there is a pathway to a use variance. But a use variance is an authorization to use land in a way that is either not permitted by the code or even expressly prohibited by the code. So take that warehousing example again. Say that it's not listed anywhere in the permitted uses for that zoning district, or in fact, it says warehousing is not permitted. You would then need to go for a use variance if you wanted to conduct that use in that zoning district. It is a very, very difficult burden. It's an unnecessary hardship test. And really, as an applicant, you need to demonstrate that for each and every permitted use in the zoning district, you cannot realize a reasonable rate of return. And you have to show dollars and cents evidence proving that. You also need to show that the hardship relating to the property is unique to you and does not apply to a substantial portion of the zoning district, that you will not alter the essential character of the neighborhood, and that the hardship has not been self-created. It is a very difficult burden. So anytime, we're dealing with a developer on the front end who perhaps a municipality has suggested a use variance approach, we often try to find if there's any other approach that may be viable, whether it's project design changes or even considering a rezoning, which I'll get into in a minute, just because that burden and that threshold is so high. So big difference between use variance and special use permit in terms of what you can push by way of your application. And then we have area variances. So area variances are usually coming along with a separate approval, whether it's site plan approval, special use permit. Those codes allow you to go through an area variance process concurrently. And that's when you're looking for an authorization to use land in a manner that's prohibited by certain dimensional or physical requirements. I think obviously everyone can think of the most basic ones, which are setback variances. Code may say you have to be 100-foot setback from the road, and you're proposing a building 75 feet from the road. You'd be seeking a 25-foot variance. Or often we'll see height variance requests. Those are probably the most common, but it's when you're looking for a variance from the dimensional requirements in the code. And really, that application, the ZBA is always looking at a balancing test. They're looking at the benefit to the applicant if the variance is granted, as compared to the detriment to the health, safety, and welfare of the neighborhood or community. And that's done through a 5-factor test, which is laid out in those enabling acts and laid out in most every local code as well. Will the variance create an undesirable change in the character of the neighborhood? Can it be achieved by some other feasible method than a variance? Is it a substantial variance request? Are you asking for a 100-foot variance from the 100-foot setback requirement, or are you asking for 10 feet? Will the variance have an adverse impact on physical or environmental conditions? And was the alleged difficulty self-created? There's no one factor that's going to control. It's a balancing test at the end of the day, and it's in the discretion of the board. But if you're presenting an application for an area variance, you want to make sure on the record, in your submission, and at any presentation you're making, you are very clearly going through those 5 factors and explaining why the benefit clearly outweighs any potential detriment. And the board is obligated to grant the minimum variance necessary. So that's something that they're taking into account as well. But you want to make sure that you're always going back to those factors in your presentation. I included rezoning here, even though it's a little bit of a different approval, because sometimes there's a little bit of a confusion with the rezoning process and what an applicant's rights are on the rezoning side of things. So I mentioned if you don't want to go the use variance path, but your use isn't currently permitted at the site you're looking at, rezoning is an option. But that being said, you do need a cooperative jurisdiction to go through a rezoning process. A municipality is not obligated to rezone a property. It is a legislative determination, and it's an amendment to their zoning code. It's often a multi-step process begun by the legislative body, the town board, the city council, often with referral to the planning board. A public hearing is required. So you do need cooperation from the municipality to go through that process. That being said, it's a strong solution if you're able to get through the process. It'll allow you to do more on the property, but you're not entitled to a rezoning. So it's just something to be aware of as we're going through each of these approvals and understanding what your rights are. There is broad discretion on behalf of a municipality as to whether or not they want to undertake that legislative action as well. And then finally, subdivision. There's a very detailed subdivision process laid out in the enabling acts and in local codes that require preliminary plat review and final plat review. And there's detailed timing and processes laid out in those code sections when you're looking to take one parcel of land and subdivide it into only a few, or, a significant residential subdivision as well. So that was a long time for one slide, but
yeah, I was gonna say,
kind of
one thing I wanted to just add is, I think a lot of times in zoning, it's like the cart before the horse situation where you're let's say a multifamily developer and you're only going to do multifamily development and you're just finding a site that might be suitable for you that you can either lease or purchase that's big enough that suits your needs. And so a lot of times you're trying to jam your project into a zoning code. And so I think one thing we always try to talk about with our clients is your upfront due diligence is really important in all aspects and other aspects that we'll get into, certainly building the record throughout the process. But I think a lot of diligence up front can really help manage your project more effectively, right? Identifying what of these approvals you even need, because that determines what boards you're before, who are your decision makers here, and what changes to your project can you make to maybe lessen some of these approvals that you might need. Like maybe you can avoid that setback variance or some other things. And saying, what can you do? What are sort of some of the priorities going on in the town? Is this municipality really in need of multifamily housing? And if so, they might be more willing to work with you on use variances or rezonings, things like that. So I think it's doing a bit more diligence on sort of where you are, what's going on in your municipality, what approvals you're going to need. I think, a lot of that upfront diligence can help manage that process a lot more smoothly.
That's a really good point and kind of leads us into this next slide. So I've only got 2 slides here on seeker, but Lindsey and I could give an all-day seminar on seeker, depending on the complexity of your project and complicating factors on the site. But we're touching on this from a very high level because we've gone through all those approvals that you're required to have. But you also need, in connection with those approvals, to go through the seeker process, the State Environmental Quality Review Act. And seeker is not a separate permit. It's required in connection with all of those approvals. And it is incredibly important to pay attention to from the very beginning as you develop your strategy and as you do some of that diligence that Lindsey's mentioning. Importantly, because seeker is the main driver of your project schedule. The regulations provide that no state or local government agency can undertake, fund, or approve an action until the seeker process has been completed. So when you're looking at all those types of approvals and what is required for your project, you can't get those approvals until your seeker process is done. So from a big picture, that really is the process that's going to drive your schedule most clearly. So again, we're not going to get into the weeds on every single seeker suggestion, outcome, path forward, but I think from a high level, in the seeker process, the board or the lead agency that's conducting the seeker review is looking to determine, are there any potentially significant adverse impacts from this project? And what you're always hoping to get, depending on project strategy, but is what's called a negative declaration. You're looking for that lead agency to say, there are no potentially significant adverse environmental impacts, which is your seeker determination, and then you may move forward with your project approvals. Often there is a lot of work that goes into getting a negative declaration because you need to demonstrate that there are not impacts to wetlands, there are not impacts to historic resources, there are not adverse impacts to traffic. If in the alternative you get what's called a positive declaration, you then need to begin a lengthy and costly environmental impact statement process. So again, this presentation is not getting into the weeds on seeker. We simply want to stress that it does drive your entire schedule, and it is a process that needs to be controlled from early on. And kind of some of our high-level recommendations on the seeker strategy is to make sure that you are constantly complying with all the procedural requirements of seeker. Having an attorney and a good project team involved early on is helpful because seeker does require strict procedural compliance. To the extent you can minimize or eliminate potential adverse impacts, that's helpful on the front end. To the extent you can move your project back and away from any wetlands or buffer areas or historic resources to eliminate those concerns on the front end and show that you've done that work, that can help expedite the process. If you've got a large scale project that's going to require a number of approvals from different agencies and boards, you need to stay on top of coordinating that process as much as possible. You want to really avoid surprises, both in any potential environmental impacts that may arise or any boards, for example, that may have a disagreement over who should be the lead agency conducting the seeker review. It's important to stay on top of things and communicate with these agencies early on so that you can address issues as they arise, or also sometimes before you even apply. If you understand what the issues are, you can try and present those in your application up front to save you time and additional board meetings. And you always are going with an eye to building the record. You want to show in the record where you've identified potential impacts and changed your project design to ensure that there are no additional impacts. You want to document your traffic studies, your wetland delineations, all the work you've done to ensure that there are no significant adverse environmental impacts from your project. You want to make sure those are clearly laid out in the record as well. Lindsey, anything else you want to add on the seeker front?
No, not on seeker, but we did get a question on rezoning.
Okay.
So the question is, what is a town's requirement to rezone a site if they've rezoned other similar sites to the new district? Does precedent matter?
Precedent does matter, and it can help you have a strong argument for why a rezoning should be issued. But at the end of the day, as long as the board is acting consistent with their comprehensive plan, they are not obligated to undertake that rezoning. That's a great question, though.
It is a great question. And I'd also look to, are they doing it for maybe illegal purposes, or are they targeting one development over another in an illegal way? Otherwise, like Kim said, there's no obligation to rezone your site, and it will be a site by site, for the most part, a site by site analysis, as long as they have a reasonable basis.
Great question.
Yeah.
Okay, so this slide kind of goes back to what Lindsey was touching on the diligence side on the front end. When you are looking to develop a project, or if you're a municipality who perhaps is undertaking comp plan amendments and overall rezonings and kind of looking at your zoning code, you want to understand, what zoning district am I in? What are the required approvals for my project? What are the standards? Am I entitled to this permit? Do I have a strong argument, or is this an uphill battle? Do I have any limiting factors on the site? Are there wetlands, which we'll talk about in a minute? Are there historic and cultural resources I need to be aware of? Are there some complicating traffic factors in the surrounding neighborhood? What boards do I have to go to for approvals? How many agencies are involved? What type of seeker review are we going to be looking at? Having a team on the front end who can help you identify all of these things and put together a step-by-step implementation plan can really save you time as you go through a process that will no doubt have some surprises and unpredictable developments. Again, that seeker process and timing, being able to drive that schedule. And you want to stay on top of the process, ahead of questions, ahead of issues as they arise. And the important important component to doing that is building the right team. I think it, depends on the size and complexity of your project, but having the right architects and engineers, the right traffic consultants can really make all the difference in the materials that you're developing and putting on the record in defense of your application. And I think I mentioned there is a presentation coming up as part of this series, Permitting Pathways, that our partner Matt Fitzgerald is going to put on. I think he's going to get into detail a little bit on how to select that team and work with that team to keep application processes moving forward. So there'll be some more insight in his presentation on that one as well. But you're always looking to keep things moving and stay on top of any issues as much as possible. And then one of those other components of what you're looking at when you're developing the site and what does my approval pathway look like is public engagement. Some of that is required. Some of that is just work you may need to do based on understanding who the neighbors to your project are. Who are the neighbors? What opposition may there be from neighbors or from anti-development or development-friendly groups in the jurisdiction? How many public hearings are required? Are there public meetings required? We always encourage you to be proactive on the front end. I think, there always has been a NIMBY component in land use and zoning. We deal with that all the time. Perhaps as it's grown, as social media has grown and allowed that to develop a little bit more. But we really always suggest, don't be afraid of public involvement and undertake it early on. And there's kind of two different elements of public engagement we'll talk about. The more community outreach side, as opposed to the more formal public hearing strategy, which we'll talk about as well. I think on the public engagement side, we always recommend engaging early and often with the public. It doesn't even need to be a formal meeting on the front end. Knocking on doors and talking to neighbors of a project and telling them what you plan to do or what you're looking to do can go a long way. Are there always going to be people who are going to oppose the project on all counts, no matter what? For sure. We deal with that. There's going to be people with concerns that you just cannot address, whose minds are not going to be changed. But there are people who do appreciate engagement early on and who can give meaningful input and help you understand the actual concerns of the neighborhood and the local issues that matter. This can happen often from a traffic perspective. Hey, this intersection is problematic. We're going to want to address that, or we're going to want to study that. Understanding as much as you can ahead of time and getting that input and seeking that input can go a long way. To the extent that you can adapt your project design and address any concerns, it's very helpful. It's helpful just from a practical perspective, but also to be able to explain to a municipality, this is what we've done before we even came to you. We were proposing this, we heard this feedback, we adapted. That can go a long way. And it helps reduce your opportunities for surprises later on. Will new issues always arise? Yes. But it is helpful to have talked to members of the public before a public hearing context. You don't want the public hearing to be the first time you're hearing of an issue. You want to be able to say, look, we've addressed that in our filing, or we'll undertake, some additional analysis on what we can do to address these concerns. But anything you can do to kind of get that input on the front end is helpful. And then developing a social media strategy. You're not going to want to respond to every commenter on every local municipal Facebook group who's going to be, spreading rumors about a project or, coordinating opposition. But it can be often very helpful to have a web page or something that can have very basic information about, hey, here's the project, here's what we're actually proposing, here's what we've changed. And again, we all know there are members of the public that you're not going to be able to change their view. But I have seen in many instances where this really does make a difference. Not only boards appreciating that you've undertaken this effort, but we had, I can think of one project, we had a relatively difficult zoning jurisdiction, and a project that we knew was potentially going to be controversial and was seeking a rezoning. So again, no obligation for the municipality to entertain that rezoning. And the developer did a lot of work on the front end, knocked on a lot of doors, held public information sessions, made revisions to the project. And while the neighbors of the project didn't necessarily think it was the most perfect outcome, they respected the work that the developer had done to engage. And when it came to the public hearing, no one spoke in opposition of the project until later in the meeting. One person rose to speak in opposition to the project, and they didn't actually live in the neighborhood. And a neighbor came up and spoke and said, look, I wasn't planning to speak on this at all, but I just want to recognize the fact that this developer spent a lot of time talking to me and made some project changes. And so now I'm going to speak in support of it. Is that the perfect instance that happens every time? No, but the front end effort is always worth it. And in fact, the city of Buffalo is going to want to know that you did that before they're even processing your application. So we always recommend this in more informal process on the front end.
Yeah, I mean, I can't tell you how many times we've gotten to a public hearing and maybe you've done a lot of engagement with the municipality, a lot of materials have been submitted, a lot of back and forth, a lot of changes. You've done a lot. You get to the public hearing, and this is the first time a lot of the people in the community are hearing about the project. And that just slows you down. Now they want to know what's going on, and they may have concerns, they may not have concerns, they may just say, I didn't even know that this was happening in my backyard. And now here it is, and I need to know a lot more information. And you can, really cut a lot of that out. Boards really don't like to, close a public hearing and vote on a decision the night that they get a lot of public opposition, right? Because it looks like the board isn't taking that into, they're not letting the people's voices actually be heard. And so, like Kim said, managing this early on is, especially for larger projects or more controversial projects, is the best way you can help manage that timeline.
And then that brings us to the more formal public hearing context, where of course, hopefully you've already had some meetings with the public and heard the issues and have kind of a preview. Most of these approvals that we went through today require a public hearing. So you're usually going to have at least one public hearing, unless you're a permitted use, just need site plan approval, to go through your project and to hear input from the public. The boards can hear from the public. And we've got some recommendations on that more formal context as well. I think when you're heading into a public hearing, you want to try and be, of course, as prepared as possible. Every municipality runs their public hearings a little bit differently. You want to make sure you know the rules. Are you going to be able to make a presentation in the beginning? Usually members of the public will have a certain amount of time to speak. Is there a rebuttal portion at the end? Will the hearing be kept open so that you can respond? So trying to understand on the front end what the format is, what the rules are, is helpful. It depends on the kind of scope or scale of your project, what team you bring, but I always recommend for a large scale complex development, you want your full project team there. You want your traffic consultant there. You want your engineer there. You want to show the board and the public that this is a well thought out, well designed project. We are prepared to answer questions, even if you can't answer them all at the hearing. And we brought the full team because there is a team of experts working on this project. And I think that that's always helpful to show on the front end. I think as a general rule, when you're presenting, you want to not forget to say the basics. Introduce yourself and what you're proposing to do and what approvals you need. What is the ask for the board? We're here on a special use permit. And then run through the reasons why the project should be approved, what's on the record, and what the code requirements are and how you meet the code requirements. It is very important at a public hearing that you, at some point in time, are responding to all of the public comments received or are acknowledging that they've already been responded to. The public hearing is not always the time for that. You don't necessarily want a back and forth that's going to keep the board there all night. You can tell when people are done. But I think to the extent that something's already been addressed in the record, it's helpful to say that. Or if there are new issues, if there are surprises coming up, to be prepared to say, hey, we've heard a few new things tonight. We intend to take this back and respond on the record. And you're always thinking of building that record, and you want to have a written submission that says, hey, here's all the comments we received from the public, and here's how they've been addressed by our studies and our analysis. So at the public hearing, delay is not the end of the world. It's not a denial. If there are issues raised and you need more time to respond to them, acknowledge that. And I think you always need to be prepared that there's going to be surprises. Public hearings can be unpredictable, even when you've got your ducks in a row as best as you can. New issues may come up. The public may not stick to the rules. The board may not stick to the rules. And boards are impacted by public comments. So again, read the room. If there's additional information that you need to develop, say that and work on it, and make sure you're getting that on the record, whether that's after the meeting or in writing following the meeting. And then I think, just be prepared for some of the wild cards as well. So you may think that you're having a board meeting that is not a public hearing, but many jurisdictions have an open floor session. They have, an agenda item at the beginning of their meeting where members of the public can speak on any agenda item that night, or they can speak on anything they want. And all of a sudden, your meeting that you thought was just a presentation has turned into a type of public hearing. Again, always be prepared to say, we've heard some good questions. We can provide information after the fact to address those questions, and make sure you are responding. It's not helpful to ignore a public comment. Acknowledge it and respond to it, and make sure you've got that clearly documented on the record. So that's kind of the land use zoning fundamentals from a high level. Lindsey and I wanted to touch on a couple things that we're seeing a lot of lately in our practice, that are impacting kind of the time and the scope of developments. I'm sure these are not surprises to everyone here attending, but I think the wetlands side of things is obviously coming to the forefront since the new regulations went into effect last year. I'm sure many of you know this is a significant issue in the state, impacting properties and development. Wetlands are regulated at the federal and the state level, and sometimes at the local level. And as we've seen kind of the scope of wetland regulation shrink at the federal level, it has vastly expanded at the state level in the last year or so. And this includes development, which includes a buffer area in the state. So it's a wetland and 100 feet within a wetland as well. So a lot of people who are looking to develop properties are now finding there's a wetland on them that there wasn't a wetland before. Previously, state wetlands were limited to mapped wetlands. They're wetlands over 12.4 acres. You go on an environmental resources mapper and see that there's the state wetland. I know that I need to avoid that wetland and 100-foot buffer area, or seek a permit, which is very difficult to obtain. And it was predictable and on a map. That is no longer the case. With the new regulations, DEC has regulatory authority over all freshwater wetlands at least 12.4 acres in size, or wetlands of any size that meet one of 11 new criteria called wetlands of unusual importance. I'm not going to get into all those 11 examples. I think Matt will touch on that in his permitting presentation as well. But the important one for everyone to know here is located in or partially within an urban area. So this is almost all of Western New York. So essentially now there's no size requirement. If you have a wetland on site, it is now likely regulated by DEC along with a 100-foot buffer, and you cannot develop there without a permit, which is very difficult to get. So we're seeing a lot of developers who perhaps have held land for a while now realize that there's a portion of their land that is essentially rendered undevelopable. And there's a lot of timing, delays, and cost involved in this. So given that this new kind of context, there's now a rebuttable presumption that any area meeting this definition is a wetland and subject to permitting requirements. So if you've got a wetland on site, it is important very early on to get a wetland biologist out there, get a delineation done, and you now are going to need to get a jurisdictional determination from DEC, which can be a lengthy process. There are timing limitations, but again, there may be wetlands on your properties now that were not considered wetlands before. So just something to keep an eye on. We're seeing this impact a lot of developments, slow or shrink a lot of developments. And there's currently a draft general permit for housing that DEC is evaluating. There's been multiple rounds of public comments on that one. The comment period is closed. That would potentially provide coverage under a general permit for certain types of residential developments. Obviously, Governor Hochul has made the development of housing an important goal of her administration, but that is not approved yet. So something to keep an eye on in terms of the residential development, but keeping an eye on wetlands on your site and the expanded scope of state regulation is a very important early diligence consideration for your sites.
Yeah, I'd say, I think most in the development world are pretty familiar with just a phase one environmental site assessment. It's a pretty common, right? Whether you're leasing, but especially if you're purchasing property, that's one of the first things you engaging, a consultant to do a wetland assessment is probably something that should just get baked into your regular practice. So that no surprises come out later on down the road and you find out that there's a large chunk of your property that might not be developable. Okay, so, like many of these topics, Kim said, we could spend a lot of time on any one of them. And certainly the impact that the Climate Act has had on development is something that, we could spend at least an hour on. We will have future meetings. We're putting a lot on Matt. Matt will probably cover a little bit of how the Climate Act is impacting some of the permitting regimes, right? There is a big shift in how regulatory permits and regulatory approvals are handled now in New York, given the Climate Act. And so, something to keep in mind for Matt's presentation. And we will have a topic coming up in June called Navigating Data Center Development. So certainly this is something that that will be covered there as well. Sort of the impacts that infrastructure on large energy users is having on the system is something that that's an issue causing an impact on development everywhere. And we will also have a specific topic in January of next year on regulatory and energy related real estate issues, sort of see how things are evolving this year. But one of the things we did want to flag in particular that we're seeing have an impact is the All Electric Buildings Act. It was supposed to go into effect January of this year. It would apply to all new construction for buildings under 7 stories, starting in January of this year, and then larger buildings following in a couple of years. At the end of last year, the implementation of this was paused. So this isn't a mandate right now for all new development. But we are seeing this. It is something that is currently in place for affordable housing. If you want to get certain tax credits, LIHTC credits, compliance with the state's climate goals is something that you have to comply with. So we are seeing this already come into play on affordable housing development. And overall, sort of the impacts here on converting everything to an all-electric system, right? These are really your impacts on development, your timing, your costs, right? So timing, projects may require longer lead times. We're starting to see this already happen with the utilities, with the planning and coordinating with utilities is taking longer and longer. Utility providers are doing what they can to ensure grid readiness, but this is really being handled a lot of times on a project by project basis. So delays can create ripple effects here on your construction, on your financing, on all of that. And then, costs, right? There is limited local grid capacity. There are electrical infrastructure upgrades that are required. There are significant costs associated with that. And really, who should pay for that, right? That's sort of an ongoing debate right now, is should that be borne on a project by project basis by the developers? Should that be something that the utilities cover? Which means is it the ratepayers? Is it you and I covering a portion of the costs for all, improvements? And, we'll cover this more in the data center development, but there is a real push here at the state level by Governor Hochul to make sure that the costs for your large energy users, in particular data centers, really, this is targeted at, that they're paying for these upgrades, that they're covering all those costs, and that there's protection in place for the ratepayers. So just a couple of things to sort of keep in mind and to keep our eye out. At some point, we'll probably have more clarity at the end of the year as to when the implementation of the All Electric Buildings Act, if that will continue to be paused, if that will go away, or if really it'll most likely start to get implemented. Okay, and before we move on, there's a question on wetlands. So the question is, have you heard any indication of banks requiring wetland studies associated with vacant land purchase or additional land development? So really on sort of the lender side, I don't know that I've seen this be mandated by banks just yet. But I think it's something that, you are likely to start seeing if this does, right, if we are starting to see people get financed and then issues come up after the fact. So yeah, I mean, we can certainly touch base with our banking folks and see what they're seeing. But I haven't seen it be an absolute mandate yet come out of banks when they're financing construction projects or property acquisitions just yet. Okay, so we have a few case law updates that we wanted to flag. And really, these first few, I'll go through pretty quickly. They're really just sort of a reminder of everything that Kim said before, which is all about building your record. So in this case, with the city of Yonkers, this was for a special use permit, but really, this standard does apply pretty generally to all of your zoning approvals. The board needs to have reasonable grounds for making the decision they're making, and that it's supported by substantial evidence. So we have a few cases here where, really based on what was in that record, is how that case came out. So in this case, the court said there was no evidence adduced demonstrating that the health, safety, and welfare of the neighborhood would be detrimentally affected. So there was no evidence here, nothing to support what was going on. So the court, the city of Yonkers denied a special use permit, and the court overturned that. So if you move on to the next couple, it's sort of the same thing. Here in the village of Southampton, same thing. There was no evidence before the board that there would be an undesirable effect from the approvals that they issued. But in the town of Hempstead, the town's determination was upheld because it was supported by specific eyewitness testimony and documentation, and not just generalized community opposition. So you really have to make sure, right? It's not just people coming out saying, I don't like solar. It's people actually providing specific testimony, or you have reports or something in the record to actually support why you're making the decision that you're making. And then the last one, Chen, sort of the same thing. The city was looking to build a new homeless shelter. It received a lot of community opposition, but it was pretty generalized. And the court searched the record and found that the Department of Homeless Services, the city's Department of Homeless Services, had done a lot. They had provided a lot of information on similar facilities that they had looked at. They had looked at closures that were planned. They had looked at alternative sites. They had a lot of evidence in the record to support that this new shelter wouldn't have a significant negative impact on the community. And I'll also just flag one other issue that came up in this case, which comes up, from time to time in these Article 78s, which is, what what is the record and is there any opportunity to do discovery beyond that record? And for the most part, Article 78s are meant to be an expedited review process based on the record that was before the board when a decision was made. There's very limited instances where you can do discovery after the fact. So that's why building your record, responding to comments at the public hearing, providing materials, documenting what you're doing. That's why that is so important, because when you do get to court, if you're in the unfortunate position of finding yourself in court, challenging or defending one of your decisions, it's based on what that record already is, and there's limited opportunities to try to correct that in the court. And then just a couple other, cases we wanted to flag as sort of cautionary tales. Don't forget about your county referral. You're under GML 239. A lot of zoning applications require a referral to your county planning board. And this case was, really interesting where, municipalities can have an agreement with their county to exempt certain approvals from county review, as long as they're really considered a matter of local concern. Here, the Village of Brockport did have an agreement with the county. Certain approvals were exempted, but here, this agreement apparently did not exempt all area variances, and the area variance that was at issue here was not on that list. So the court said, nope, that agreement isn't in place. A county referral was needed. And here, that is a jurisdictional defect. So, right, we know that a lot of these zoning approvals have a very short statute of limitation to bring a legal challenge. A lot of them are 30 days. Here, it didn't matter. This challenge was brought more than 30 days after a decision was made, and the court said this is a jurisdictional defect. Your statute of limitations has not even begun to run because your decision is null and void. So that's a very hard lesson to learn, just for not doing a county referral. So always something to keep in mind. And next on the public hearings, same thing, you have to have good application materials that have the correct information. In this case, a property owner received a variance and the building permit to build a shed. They then built that shed. And after the fact, it was discovered that the public hearing notice was defective because the applicant put the wrong address in their application form. So when public notice went out, it went to the, 100-foot abutter or 200-foot abutter list for the wrong address. The town said, we have to do this all over again, resubmit your application. They did it. They had a new public hearing, and the board ended up denying the variance. And that was upheld by the court. The court said, yep, your public notice was defective. That's a jurisdictional defect. You cannot, you can't stand on that prior approval. And they also found that they did not have any sort of vested rights in the approvals that were issued. And so again, sort of pay attention to what's in your materials and how that process is going, because, in this case, it ended up being a built shed to a shed that had to be torn down because it was denied. And then, similarly, a next one on the public hearing, it's definitely an opportunity for the public to weigh in, but remember, it's also an opportunity for the applicant to have a chance to respond to all those comments. So in this instance, the planning board had a letter that it relied on in denying an application, but it never provided that letter to the applicant. The hearing was closed. They never had an opportunity to respond, and the court said they were entitled to a new hearing. And then next, just briefly flag, this has come up a bunch, especially in the secret context, that you get a battle of the experts and what happens, right? You're the applicant. You've hired a whole host of consultants to prepare expert reports on traffic, on noise, on stormwater management, on all these different areas. And what if you get community opposition that hires their own consultants challenging your findings? Or what if the town hires its own consultants and you've sort of got, a battle of the experts, two expert reports that say different things? Well, what happens? And really what happens is it's the board. It's up to the board. The board that has the approval authority, they get to decide. They get to look at the reports, weigh what they think is credible. And as long as they've got a justification for it, the courts will not disturb that. So it really doesn't come down to a sort of a battle of the experts. It's really up to your reviewing board. And then lastly, want to flag, this is something that came out, not in 2025, but the year before, but especially as Kim talked about, the use variance standard is a really high standard, even area variances, right? Those are balancing tests, and they can come out really different ways. And as long as you've got justification, it can be hard to challenge a denial of those. And so, we've seen this for many, many, many years. In the telecom context, courts have created this utility standard, which is a lesser standard of review when looking at variances, and in particular use variances, because those are a harder standard to meet. And what we've started to see lately is this getting applied to solar projects as well. And now we've started to get our first batch of cases of courts saying, yes, that utility standard does apply to solar development. And so there, instead of doing, a comprehensive test and looking at, the economics of what's going on in a use variance and looking at the balancing test and an area variance, instead it's a two-pronged test. You look at the public necessity. Is there a public necessity for your project? And are there a lack of feasible alternatives? And if so, if you can show both of those things, you're entitled to an approval. And, in the solar context, given the Climate Act, I think it's going to be very difficult to argue against the public necessity here. And what courts have said, and what the Freepoint Solar Court said, is that you don't just look at the local community. It's not whether the residents in the town where you're going to have a solar development, it's not whether they need solar development or energy connections or energy expansion. It's not just about that local community, but these are state goals. And so we need all of these solar projects and all of these green energy projects to come online in order to meet the state's larger statewide goals. And then the alternative site analysis, really it's just looking at, what sort of other sites might be available and seeing what you can do to rule them out. You don't need to prove that another site is impossible, but really looking at your connectivity issues, your development issues, maybe wetland issues, maybe other, zoning restriction issues. Is this really the best site that you can find? And it's really just coming up with, something in the record to prove that you've looked at feasible alternatives and that what you're proposing is the best. Okay. And there was one more question on, does a rezoning request lie on the property owner, and what would the initial process be to rezone a parcel?
Yeah, so a property owner can undertake a rezoning request, and really, we would always recommend meeting with the municipality before putting any type of rezoning request in. Meet with the town attorney, meet with the supervisor, meet with planning staff. Hey, is there an appetite for this rezoning? Make sure you've taken a look at the comp plan. You've got your arguments prepared for why it makes sense to rezone to this. And then under the Enabling Act and under, local zoning codes, there'll be a process laid out by which you would petition either the town board or the city council to entertain the rezoning request and kind of kick things off. So again, we recommend more informal meeting before you put in that application, which will go to either the town board, city council, village board, and then they can move that process forward. We like to provide on the front end everything they will need, including the information necessary to make a seeker determination on the rezoning, which, if you're looking at a rezoning process for a project, and you need to understand that you have to consider the seeker review for that entire project. So when you're preparing your rezoning application, you will very often need to have materials that are relatively detailed in connection with what you're proposing to develop, because the board may need to undertake that as part of its seeker process. So just something to keep in mind.
And then there was one question about where could I register for the data center webinar? Thank you for that question. I know that wherever you registered for this is the same. All of our upcoming presentations throughout the year are listed on our webpage. So however you registered for this, you should be able to go to that page and register for all the rest of them. But after this, I believe everyone who did register, you will get an email out and we'll include information on all of the upcoming webinars in this series so that you can register for as many of them as you want.
And here's the plug for the next one in
Yes.
May, on trends in real estate development and financing. Any additional questions? Okay. Well, thank you.
Right at
everyone.
9 to right at 10. Look at that.
Thank you, everybody, for taking a chunk out of your morning. Happy birthday to Lindsey again. And we hope you'll join us for some more of these webinars. Thanks,
all.
everybody.